Kennedy.
Thank you, Mr. Chairman. Judge Wildheimer, am I saying your name right?
You are. Thank you, sir.
Yes, ma'am. Who is Brian Labus, L-A-B-U-S? Is that name?
Brian Labus, if I am remembering correctly, since I had 2 years in criminal, about 2,000 cases assigned to me, I believe he was the first human trafficker case we had in Montgomery County. Am I remembering that correctly, Senator?
Well, he was 25 years old. He was a nursing assistant.
Oh, that's a different case. I do recall that one. Thank you, sir.
Nursing home. He sexually assaulted one of the patients. She had Alzheimer's. Do you remember how old she was?
The process of nominating and confirming federal judges in the United States is one of the most consequential responsibilities entrusted to the United States Senate. These lifetime appointments not only shape the outcomes of individual cases, but also influence the broader trajectory of American jurisprudence for generations. As such, judicial confirmation hearings are far more than ceremonial formalities. They are moments of intense scrutiny, revealing the intersection of law, politics, public accountability, and moral judgment. The Senate Judiciary Committee plays a central role in this process. It is charged with interrogating nominees on their legal philosophies, judicial records, and interpretations of constitutional and statutory law. Beyond assessing credentials and professional experience, senators often seek to probe the nominee's values, temperament, and decision-making under pressure, particularly in complex or controversial cases. The stakes are high. Federal judges have vast discretion, often presiding over cases that involve issues of life and liberty, civil rights, corporate accountability, and the limits of governmental power. This particular hearing, involving Judge Wildheimer, a nominee for an elevated judicial appointment, exemplifies the contentious and high-pressure environment of such proceeding. In a tense exchange, Senator John Kennedy of Louisiana presses the judge on a past sentencing decision in a case involving a particularly disturbing crime, the sexual assault of a 93-year-old woman with Alzheimer's by a 25-year-old nursing assistant, Brian Labus. The case unfolded in Montgomery County, and the facts, as recounted by the senator, are deeply unsettling. According to public reporting and the hearing transcript, Labus assaulted a vulnerable elderly patient under his care, an egregious abuse of trust. Despite the severity of the crime,
he sexually assaulted one of the patients. She had Alzheimer's. Do you remember how old she was?
I do not remember, but I do know she needed to be in a nursing home and was incapacitated.
She was 93 years old. He's 25. He gets her alone. She's got Alzheimer's, and he molests her. This meathead made bail, and because he's like a rock, only dumber, he immediately goes out and drives while smoking dope. He gets arrested. And he came before you for sentencing. Do you remember what sentence you gave him?
I do, and my recollection of the facts is slightly different. My recollection is his DUI arrest was after my sentencing, but regardless, you are correct, he had the DUI. This was a negotiated sentence in this case.
What sentence did you give him?
I do not recall the terms of the negotiation. I do remember it was a negotiated sentence, and
You gave him 11 months and 15 days, didn't you, for assaulting this woman?
If that is what your records show, I have no reason to disagree with that.
And he grinned, according to the news reports. Grinned at you. You remember that?
I do not recall that. I do have recollections of this case, and if I may, Senator, it is a case in which the Commonwealth had...
Yes, ma'am, but I don't want you to take all my time telling me about the case, because I looked at the case. For the DUI, after this meathead assaults a 93-year-old Alzheimer patient, you gave him 11 months and 15 days. For the DUI case, you gave him 3 days to 6 months.
Senator, the
that right?
DUI was not in front of me. I was out of the criminal division by then, and I believe that went to a judge that took my cases when I was transferred to the civil division.
Ms. Perry, tell me the difference between res judicata and collateral estoppel.
Collateral estoppel is also known as issue preclusion. Res judicata is also known as claim preclusion. In issue preclusion, the question is whether the parties have previously litigated to their merits and finality the same issue, in which case they would not be allowed to relitigate the issue. In claim preclusion, the question is similar, whether the parties have litigated to finality on the merits claims, and they would not be allowed to relitigate those.
Okay. Tell me the legal meaning of present sense impression.
Present sense impression is an exception to the hearsay rule. And in present sense exception cases, it's the general idea behind the exception is that a person is unlikely to lie if they are simply giving their present recollection of exactly what is occurring as it is occurring. And therefore, those statements are allowed to be used in evidence, even though they are, by definition, hearsay.
Very good. Tell me, what is, we all pay taxes on income.
Despite the severity of the crime, Labus received a sentence of only 11 months and 15 days, under a plea agreement accepted by Judge Wildheimer. Senator Kennedy, known for his direct and unvarnished style of questioning, challenges the nominee sharply. He refers to the defendant in starkly critical terms, expressing moral outrage that Labus was released on bail and later arrested again for a DUI offense. Judge Wildheimer, in turn, offers a restrained and procedural response, emphasizing the constraints of the legal system and the evidentiary challenges presented by the case. He explains that the sentence was the result of a negotiated guilty plea, a common, if often controversial, mechanism in criminal law that allows prosecutors and defense attorneys to resolve cases without the uncertainty and expense of a trial. The judge notes that the prosecution faced evidentiary insufficiencies, making the plea deal a pragmatic, if imperfect, path to acknowledging the crime and offering closure to the victim's family. This exchange is more than a debate over one case. It reflects the broader tensions inherent in judicial work. Judges must navigate a system in which the pursuit of ideal justice is often constrained by the availability of evidence, the decisions of prosecutors, the rights of defendants, and the procedural rules that govern criminal litigation. Moreover, plea bargaining, while efficient, frequently invites criticism for producing outcomes that may seem disproportionate to the gravity of the underlying offense.
I know you do because the FBI checked. They do a thorough background check. And I do too. What is income?
Well, the IRS regulations are extremely complex when it comes
conceptually,
to
what is income?
describing income, but basically it is anything of value that you receive throughout the year. So it could be gratuities, it could be wages.
Well, what if I'm asking you how you go about analyzing this. Let's suppose Senator Durbin starts a new company and he takes it public. And I decide to buy some stock because I believe in Dick Durbin. And I buy it at 10. And it goes to 20. And I'm feeling all warm and toasty. But I don't sell it. I want to just, because I think it's going to go to 30, because I believe in Senator Durbin. Can government tax me even though I haven't sold it?
I am by no means a tax expert, and I would like no one to rely upon this tax advice. My understanding is that would be an unrealized capital gain, and you would be taxed upon it at the time that it is realized. But again, I am not a tax law expert.
Why is that? I mean, what's the basis for that?
Why am I not a tax law expert?
What's the basis for that?
I believe the basis for that is that those are somewhat imaginary gains that can rise or fall as the market rises or falls. And so they tax you upon it at the time that you actually realize that interest.
Okay. Gentlemen, I'm sorry, I'm out of time. I didn't get to ask you questions, but good luck to you.
Thank you, Senator. Judge Wildheimer, do you want to explain the sentencing in that case?
Thank you, Senator. When we have cases in which there is a guilty plea, in a case like the Labus case, which I do have a specific recollection of, I would often ask for a sidebar and ask for a justification for me accepting the negotiated guilty plea. There have been times that I have rejected negotiated guilty pleas. In that case, there were evidentiary insufficiencies on behalf of the Commonwealth. And when that occurs, it is important for me to make sure that the crime is recognized, and the effect on the victim is recognized, even if it might not be to the same extent as if someone would have been found guilty after a jury and the sentencing would have been exclusively up to me. This at least brings closure to the victim's family, and it brings closure, a recognition of the crime. And for that reason, in this case, I accepted the negotiated guilty plea.
Thank you. And I want to thank all the members of the panel. Quick logistic.
In addition to questioning Judge Wildheimer about his sentencing decision, Senator Kennedy also tests his knowledge of legal doctrine. He inquires about present sense impression, a hearsay exception that allows certain real-time statements to be admitted as evidence. He further introduces a hypothetical scenario involving unrealized capital gains to probe the nominee's understanding of tax law and economic reasoning, highlighting the diverse legal knowledge expected of a federal judge. The nominee responds competently, if cautiously, particularly noting that tax law is not his area of expertise, a reminder of the vast breadth of legal domains judges are expected to navigate and the limits of any individual's mastery of all areas. Nonetheless, Judge Wildheimer demonstrates fluency with key legal principles, reinforcing his qualifications on a doctrinal level, even as the controversy surrounding his sentencing decisions raises questions about judgment and judicial philosophy. Ultimately, this hearing illuminates the central dilemma of the modern judiciary: how to reconcile procedural justice with moral accountability. As this hearing reveals, the confirmation process is not only a legal vetting, it is a public referendum on what we demand of our judges: impartiality, competence, compassion, toughness, restraint, or all of the above. And in cases that evoke deep emotional and ethical reactions, such as crimes against the elderly, sexual assault, or repeat offending, those demands can be particularly unforgiving.